moving on to our panelists. We are joined to my very left by His Excellency Ambassador Dato Amran Mohamed, who is the permanent representative of Malaysia to the United Nations Office and other international organizations in Geneva. Prior to this, he was the ambassador of Malaysia to the Republic of Turkey from 2014 to 2016 and the undersecretary of the Southeast Asia Division at the Ministry of Foreign Affairs. He has served in various other capacities at the ministry and abroad. To my direct left is Ms. Honey Tan. She is a member of Empower and has been actively engaging in the Universal Periodic Review, especially contributing as one of the founding members of COMANGO. She is a human rights lawyer, practicing primarily in the areas of family law, and actively engages in public interest litigation, particularly in areas of equality and non-discrimination. To my very right is Mr. Jerald Joseph, who was appointed as the Commissioner of the Human Rights Commission of Malaysia, often known as SUHAKAM, in 2016, and is currently the Vice Chair of the Commission. For the last 25 years, Mr. Joseph has been a human rights defender specializing in the rights of indigenous people, elimination of racial discrimination, economic, social, and cultural rights. He is also one of the senior civil society members who has led the Malaysian NGO's reporting process for the UPR working group in Geneva last fall and has supported other UPR processes for Malaysia. And finally, we have Mr. Roger Chan. Mr. Chan is the current secretary of the Malaysian Bar and is the co-chair of the Bar's Human Rights Committee. He has also formally served as the chairperson of the Constitutional Law Committee and the chairperson for the Environment and Climate Change Committee. In his current role with the Bar, he has crafted recommendations for Malaysia's Institutional Reform Committee regarding 6 core international human rights conventions and advocates for the Bar's position within the government. And with that, I will yield the rest of my time to our panelists, and we can perhaps begin with the ambassador.
Thank you very much, Angela, and thank you for the kind introduction. Let me begin by thanking the organizers of this side event for inviting us from the Prime Minister of Malaysia to be part of this occasion. And of course, I really appreciate the opportunity to share the government's perspective on the follow-up to the review of Malaysia that was undertaken last November. And the focus is on the implementation mechanism, so I really appreciate the opportunity to share our perspective that we have now in consultation with Foreign Ministry, and I also look forward to the views and comments from the other panelists and perhaps from participants of the side event as well. And before I proceed, let me acknowledge the presence of Commissioner Jerald yourself from SUHAKAM, the Vice Chair now of SUHAKAM, and Ms. Anita from Empower Malaysia, and Mr. Roger Chan from Malaysia Bar Council. And of course, as we are all aware, Malaysia underwent the UPR on the 8th of November last year. And from our own assessment, it was a successful review of Malaysia, the 3rd review, and 268 recommendations came up from the review, and 147 of which have been accepted by the government of Malaysia, and the remaining 37 have been accepted partially, and about 84 recommendations are noted. So this is basically the initial position that Malaysia has taken on the recommendations emanating from our last UPR in November. Of course, Malaysia is firmly committed to the UPR process. We highly value the constructive and cooperative approach that the UPR process seeks to promote in our efforts to advance the promotion and protection of human rights, including in Malaysia. And when we presented our report to the working group of UPR in November, the theme was embracing change. That is basically following the many significant changes in the domestic environment in our country following the general elections in May. And we have a new government after 61 years, and now we refer to Malaysia as New Malaysia as well, which is the topic of our discussion today. Let me move on to the mechanisms that we are looking at now in order to ensure effective implementation of UPR recommendations. When I refer to UPR recommendations, it includes those recommendations that Malaysia accepted and those recommendations that Malaysia has partially accepted and those that we have noted. So it's all part of the follow-up of the UPR process implementation. Sorry. And how do we go about doing the monitoring, implementing the UPR recommendations? At this stage, we have the Ministry of Foreign Affairs of Malaysia as the coordinating ministry for UPR process. This is a practice common to many countries as well, because it involves our engagement at international level. And the Foreign Ministry is responsible for coordinating UPR for Malaysia and has therefore identified recommendations that will be kind of transmitted or forwarded to different ministries in Malaysia according to the portfolios. And then the recommendations, as I mentioned, include those, basically all the recommendations that emanated from our UPR. And it is the responsibility of each and every ministry or agency in Malaysia to implement specific recommendations under their purview, either on its own or I think very often nowadays we see in consultation with other ministries, given the cross-cutting nature of many recommendations made to us during the review, as well as in consultation with other stakeholders, including SUHAKAM and also our civil society organizations. And of course, I think in the process also, the ministries concerned will identify challenges and also steps to address those challenges. And coming to the specific mechanism, already there is a draft or comprehensive database or UPR monitoring matrix which has been developed upon the initiative of our CSOs. I think COMANGO played a crucial role initially in the development of this matrix. And of course the matrix has been already reviewed by ministries and also by SUHAKAM and the UN country team in Malaysia as well, together with our CSOs. As I mentioned, the matrix is a cross-cutting database, and the intention is to include in this matrix all the UPR recommendations, as well as SDGs, and recommendations that come from other treaty bodies, in particular those treaty bodies of conventions that Malaysia is party to, as well as recommendations from HRC or Human Rights Council special procedures. So there are also contained in these metrics indicators, specific indicators and status of implementation of the recommendations. So we expect the matrix to be a rolling document that will be improved upon as we progress to monitor the implementation of UPR recommendation as well as recommendations from SDGs and others which I have mentioned. And the thinking in the Foreign Ministry now is that there will be a half-yearly review of this matrix. This review will follow kind of multi-stakeholders meeting conducted by Foreign Ministry together with our line agencies, our national human rights institution, SUHAKAM, and also our civil society organizations. And there could be other parties as well, especially from UN agencies which are based in Malaysia. So there will be a half-yearly review of the status of implementation of the recommendation, and there will be kind of a status report at the end of the year based on the review conducted twice a year. There will be a status report highlighting the progress and to some extent, I think, challenges in the implementation of UPR recommendation. And this progress report will be made public, and at the moment we are thinking of putting up the report on the website of the Foreign Ministry of Malaysia. And I think in the process also there have been a discussion even involving our Foreign Minister that we may avail to technical assistance from our partners, in particular from the Office of the High Commissioner for Human Rights in Geneva or the regional office in Bangkok. The idea is to proceed as we pledge to the review on the basis of multi-stakeholders partnership in the implementation of the UPR recommendations. And of course the process will be ongoing until the next review of Malaysia, and I suppose it will go on. I think I stop at that point, Angela, and we may come back to some of the other issues as well. Thank you very much.
Thank you. Next, if we can have Mr. Joseph.
Good afternoon. Thank you to our Chair for organizing this event. His Excellency Ambassador Dato Amran, colleagues Hani and Roger from the Bar Council. So it's already from the onset, I want to say this is a good picture of what the change is. You get government, commission, Bar Council, civil society, already sitting together and discussing. Not agreeing on everything, but the process of moving forward, I think, is what Ambassador alluded to earlier. And that's, I think, what I want to make my first statement, that there is a shift, a change in terms of operation for UPR from the onset even last year. There's engagement, there's discussion, there is note sharing, as well as now. So I don't foresee a shift in that kind of follow-through engagement as what was just mentioned. I also want to take note that the Commission is also, we continue our work to push the government to its, what we believe as minimum standards of human rights. But like this morning we read in the papers the discretion of mandatory death penalty is now returned back to the court, which is a really good first step. Before, many of the death penalty, the courts just had to say yes and that's it. So for us, it's a good first step, maybe towards the abolition of death penalty in the future. And then also, the Foreign Minister was here 2 weeks ago and he gave a speech at the Human Rights Council, actually inviting, making an open invitation to all mandate holders and special rapporteurs to come and visit the country. And I think that's the way to move forward. The government may not agree with the recommendation, but the first start is to keep that open. And there's been a lot of new initiatives being tried. I can give you an example, of course. Recently, the announcement of the Royal Commission on Inquiry on the death camps in Weng Kalian. That's a new step. So, the highest body of an independent has got 6 months to come up with a conclusion on who's accountable for that. I was also invited to be on the Independent Committee on Migrant Workers, and we've completed a report. It's at the cabinet level to reform what has been a systematic abuse of migrant workers in the country. There's an Electoral Reform Council that has been doing an open consultation with a mixed batch of people. There's been a push and an appetite to set up a Children's Commissioner or a Children's Commission. So I think these are some amongst the flavor that will make the implementation of UPR in the right direction. Nevertheless, the UPR will present the government with a whole list of improvement that need to happen. So there are still difficult issues, and I think some of the, as the Ambassador said, there are some noted recommendation and some fully and partially accepted. And I think the difficult issues which I want to state is like, we believe that the treaty ratification should not be on the difficult path. We should move in that direction because this new government has spoken about wanting to ratify more. So we are really amazed at the good news of the ratification of the International Criminal Court just last week, and well done to the Foreign Ministry for getting us there. But the Convention Against Torture was something we thought we were very close to, and I think we should continue because that was the feeling of civil society, the Commission, and others. ICERT is a sad event because the Treaty on Racial Discrimination, the government of the day, the new government actually said that they are not going to ratify, and the Commission believes that cannot be an option because we are a country that actually our value is premised on inclusivity, on non-discrimination, on multiculturalism, multi-religious framework. So ICERT is a kind of a treaty that we should work at. There could be difficulties, but I'm sure we can manage that. The other issues are child marriage, stateless, refugee issues, and I think this is going to be the flavor of how UPR will need to be managed, and that's why I think we will need a human rights framework within each ministry. I thank the ambassador for already sharing how the framework for monitoring is going to happen, the 6-monthly monitoring. And the Commission wants something at that level to happen, but it should be a permanent interministerial tracking system. I think that's what the Foreign Ministry is now looking at. But to make that happen, we also realize, I've gone to some of this interministerial meeting, but the officers are new every time as a different officer, so you cannot actually follow through. So maybe one of our proposal in our discussion with the government is even to maybe have dedicated human rights officers or units within different ministries will then help the Foreign Ministry actually do the tracking in a very systematic way. So I think the retraining of the civil service in the different ministries would be something maybe the Foreign Ministry will need to do in order to have partners who would understand this process. Because now we only go to the Foreign Ministry and other ministries are a little bit not so clued in on the big process of UPR. So I think retraining is very important, and the professionalism of the civil service in terms of human rights is important. Maybe my final point is on the difficult issue is also the issue of race and religion in Malaysia. And I think the Commission has always taken pride that we are a pluralistic society. And moderation has been actually the battle cry from the last government till this government. I mean, it's the same framework. And I think we should not use that as a reason not to move upwards in terms of our minimum compliance for human rights. So I think there is a growing justification sometimes by political parties and some NGOs using religion or sometimes using Islam as the reason not to comply. And the Commission has had dialogue with a variety of people who then give us another interpretation that actually Islam actually sometimes is even far ahead than the minimum standard of human rights. And I heard it from the minister himself, Mujahid, in one of our conference. He proved, I mean, he's articulate on religion, I'm not on Islam. And he proved many instances where the minimum standard of this hall of the Human Rights Council actually is far lesser than what the religion of Islam demands. So I think we must take on that approach, and I think that's probably a good way with what the minister is trying to do. But I think public education is needed. I don't think we are going to get change if we just have discussions among government agencies and civil society and ourselves. But the large public needs to come on board that this is a new Malaysia that is actually comfortable with human rights. And maybe to do that, we actually hope the Commission stands ready to work with the government of the day, but we would definitely need political courage to take that forward. Thank you.
Great, thank you. And Mr. Chan, if we could have you speak next.
Thank you very much, Madam Chairman, Excellency Ambassador, Ms. Anitan, Jerald. First of all, thank you very much for inviting me to speak on the way forward in the context of New Malaysia in respect of UPR recommendations. Some of the points actually I have thought about in moving forward in this New Malaysia context have actually been mentioned by Excellency Ambassador. and he talks about developing a matrix, which is a very good approach. Simultaneously, in civil society discourse, there is also another mechanism that is also currently developed. I think it does not differ much from the matrix approach. What we have in the present moment now, I am made to understand that there are two approaches that civil society is thinking about, and thinking very hard, in fact. First, the thematic approach, which has been discussed at length since the January election, G14 results. And the other one is what you call the cluster approach. And I noticed from my discourse with them, a lot of time has been spent on this. And it comes to a realization that the thematic approach would be very topical, and in fact, with all the various areas and subtopics to be addressed and all that, so it turns out to be a very complex sort of approach, and it requires long-term and also lots of resources on this to address those difficult areas. Therefore, the cluster approach was seen to be very favorable in the sense that it go on cluster and you address the various ministries and agencies that will systematize everything. So I believe that the best approach to be taken, and I would propose it today, would be the cluster approach, which is ongoing, where we talk about the particular issues and we populate it with the developments that have taken place. Today, my second point would be to enlighten you on the attention that has been paid to the recommendation process and the particular attention upon which these recommendations are taken. I noticed that some of these attention have caught much interest in respect of certain areas, whereas in respect of other issues, I think because time does not permit, I will take on when question time starts. But for the areas where more attention has been given, I will deal with it, and these are the death penalty. Now, the death penalty is a very dynamic sort of issue that we are seeing. By the time you discuss, you will find that new developments are taking place. But to compress whatever developments that have taken place, I would just say two things. The de facto Minister of Law in October says the death penalty will be abolished, full stop. And that is taken to mean that it will be abolished absolutely. The question of mandatoriness does not apply. I would like to convey the Malaysian Bar Council's position that abolition of death penalty must be absolute. It may be argued that there are constitutional implications involved when you take away the discretion of the judges. But we have always been carrying this point that the legal system in Malaysia is not infallible. Once you sentence somebody to death, you must either guarantee that you make no mistake, or you are saying that we can do away with mistake, or the timely legal principles where if 10 people are found guilty, it is better to release them, free them, rather than to innocently sentence or convict that person. Now, this is the time-honored principle that you can find in every law books and legal jurisprudence. And the reason is simple. And to illustrate my point on this simple principle, we have the case of Karti Gesu many years back. And he was sentenced to hang. the judge relying on the evidence of the witness. And we cannot say that the judge was wrong. The conviction stood and there were legal principles being followed. You cannot blame the judge. However, the unfortunate thing was the witness lied in the witness box. It came to a realization at the federal court level. And because of the reliance of this evidence that the witness has perjured, then the federal court reversed the death sentence. My question to ladies and gentlemen is, had there been no revelation that this particular witness had lied and spoke of untruth and half-truth in the witness box, could we save the prisoner, Mr. Kartikesu? Had he been hanged, there would be no reverse of the particular situation. My next area of contention where we need to push the mechanism would be oppressive and detention without trial laws. The government has promised that they will do away with this. Sedition Act is number 1 on the list. But we were taken to some kind of satisfaction where this act is going to go by the government imposing a moratorium. However, the first 11 days of this year, 2019, we have the act used against 4 people. And the Bar Council has to call upon the government to reinstate the moratorium. I think these mechanisms have to be pushed further in the sense that we need to keep those promises in place. And if you do that, then it is going to send a message that confidence in the governance and integrity of government in respect of UPR recommendations would be the primacy of the matter and would be very important. Thanks.
Thank you, Mr. Chan. Ms. Tan?
Good afternoon, everyone. Okay, I have mainly 4 points to make. So the first one is about what the ambassador had said about the theme for the UPR last year was embracing change, and that's really wonderful to hear. But some things have not changed. I think one of the things is that we've always called for the reports to be translated to Malay, the national language, so that it will be more accessible to everyone. I think that's one of the key things that we have been talking about for a long time. But the nice changes that happened is the recent accession to the Rome Statute. So now we're part of the ICC community. Again, back to things that have not changed, as what Roger had just said, Sedition Act, SOSMA, all these remain despite promises made when the government was in opposition. Now, my second area will be talking about low-hanging fruits. So back to the UPR recommendations and also the CEDAW recommendations, CRC, and bearing in mind the SDG goals. So why don't we accede to the optional protocol to CEDAW and the third optional protocol to the Convention on the Rights of the Child? I think that's something which is easy to do and actually will not have that much of a serious impact or, to certain communities and all that. So can we just pick the low-hanging fruits first? On my third point, okay, this is where we are heading into choppier waters. Things that have not changed, marital rape, female genital mutilation, child marriage, and the language that comes from the current government, and the inaccuracies in law. Sometimes it's quite sad and sometimes it's irritating and most times it just makes a lot of us very angry. So let's deal with something simple like, okay, not simple, but something which is within the control of the federal government. As many of you know, religion is a state issue. But we have 3 federal territories in Malaysia, and the laws in the federal territories of Malaysia are, they're done in the parliament. So when it comes to issues like child marriage, if you say that child marriage is a Islamic religious issue, which is a state issue, then the federal government should lead by example by amending the necessary laws under the Federal Territory's control. So something simple which we all think has gone but has not, and it's continuing, is the unilateral conversion of children. For as long as states have the Administration of Islam Act, it comes in various names, so long as we have those sort of state enactments in place where one parent or a guardian can change the religion of a child to Islam without even informing the other parent, we will continuously have to fight this issue of unilateral conversion of children. So why don't the Parliament, in looking at the Federal Territories Act over the administration of Islam, do something about this? Also about child marriage. Now, the issue with child marriage for the Muslims is not the age. The problem is the discretion given to the Sharia court judges to go below whatever the age is, 18, 16, 21, you know. You can go as low as 9, 11. What's happening here, right? So if you say you cannot deal with the states, leave it. Just deal with federal territories first. So let's not hear all this again. Now, the other issues, of course, is on the rights of the lesbians, bisexuals, and gays, you know. Most recently, if you have been following about the International Women's Day March, so much has been blown out of proportion about what actually happened for the IW Day March, which is actually International Women's Day. Actually, the women's groups were asking for so many things, but because there was very selective reporting and, of course, followed up by, you know, everything going viral, it made it seem as if the whole march was about, you know, gay rights. Actually, it's not. Not that there's anything wrong with it, but it's not. And now what has happened, the blowback, is that women human rights defenders have been summoned by the police for investigations. And again, inaccuracies in law, like, oh, they didn't have a permit. You know, under the Peaceful Assembly Act, we don't need a permit. And the women's groups did give more than 10 days notice. So all this misinformation and inaccuracies, factual and legal, is just going everywhere. So I'm just going to wind up with another, like, really, you know, tough issue to deal with, which is like race and religion. So I think Haiti, actually, when we were watching the review, Haiti made some really interesting recommendations on religion. One of them was that you should not put a person's religion on the IC card. Can we think about doing that? Of course, the other thing is about changing religion. So I think the problem here is changing the religion of Islam. And of course, you have issues, some recommendations made by the USA about, you know, freedom of religion, in the sense also that you must look intra-religion, not just inter-religion. So we have to look at the rights of the Shias and the Ahmadiyas. So let me see. Maybe I'll just stop there and take some questions. So thank you very much.
Thank you, everyone. That was definitely a very informative discussion. If anyone has any questions at this time, we are happy to have the panelists take them. Yes, please.
My name is Alice Edwards. I'm head of the Secretariat for the Convention Against Torture Initiative, which is an intergovernmental, cross-regional initiative of the governments of Chile, Denmark, Ghana, Indonesia, Morocco, and most recently Fiji. Very happy to hear of the progress in Malaysia and the wide various views of the panel. Congratulate the government for ratifying the ICC statute, and also for the UPR accepted recommendations around ratification of the UN Convention Against Torture. We were very pleased to host a delegation from Malaysia, government delegation in 2016, which also included the Malaysian Bar Association, and also to support the visits of Mr. Hani Abdul Wahab from the committee. So congratulations on, there have been a number of steps. I just wanted to, on behalf of the governments that we work for, just offer CTI's support if there's any further technical assistance, or you'd like to hear from other governments and their approaches to various issues if you've got particular challenges, and we'd be more than happy to arrange a visit to Malaysia if that would be of interest. And finally, just to invite Malaysia to join CTI's group of friends. It's an informal network of governments. We currently have 41 governments in our friends, as well as a range of international and national NGOs and independent experts, which would be an informal network that you might then have access to a range of governments who may share some of your issues and may have some experiences to share. Thank you.
Thank you. Yes.
Thank you very much. I'm Budi Cahyono from Franciscan International. First of all, I would like to congratulate the organizers of this for this side event. That's not very often for us to have side event on Malaysia, so I'm very much excited. The second thing is that I also would like to congratulate for the new government, and it shows really that there is a new openness of dialogue between the government and civil society, especially at the United Nations. So once again, this is something that we need to congratulate. Also, the third, I think the ambassador has explained about the different commitments given by the government of Malaysia for the UPR recommendations, including how the follow-up will be done. And I think it's also something that is very commendable, because not many states will have such mechanism in the UPR implementations. However, I agree with what Ms. Hani said regarding the issue of freedom of religion, and indeed it's part of our concern, our network in Sabah especially. What I would like to know is that what is the main reason why most of the recommendations on freedom of religion are rejected, and it's a bit regretful for us that there is, for other recommendations we see that the openness is there, because we did also submission on the issue of migrant workers and trafficking, and we were quite nicely surprised of the acceptance of many recommendations on trafficking and migrant workers, but we were quite surprised to know that for the freedom of religion there is still a kind of elephant in the room in Malaysia. So I would like to know, with all the issues that were raised by Ms. Hani, what is the plan by the Malaysian government to start the discussion on the issue of freedom of religion. Thank you.
Thank you very much for the question. First, let me say something about the CTI. When the Foreign Minister was here for the Halva segment of the Human Rights Council, he took the opportunity to meet with ambassadors of Indonesia, Morocco, and Denmark as part of the CTI engagement. And the program was kindly arranged by SUHAKAM. And he had a very good discussion. In fact, there were some new developments that the ambassadors shared with him that he managed to take back to Malaysia. And in fact, during the meeting, he did mention about CAT being one of the low-hanging fruits when it comes to our commitment or pledge commitment to ratifying international human rights convention. So I think progress is being made in that respect as well. And of course, we are very appreciative of the efforts undertaken by CTI in terms of providing information, education, and even training for the past few months, including the one that you mentioned. And there's a question about freedom of religions and recommendations in the UPR. When we consider the UPR recommendation, it's not just the question of whether we would be able to implement the recommendation, but you also take into account the circumstances in Malaysia. I think the main stumbling block for the issue of religion is because in our system, religions falls under the jurisdiction of different states on that, and therefore this requires a kind of broader, more extensive engagements with state religious authorities. And of course, this brings us to the whole issue about educating the public, which was mentioned by some of the panelists. And it's creating awareness among the people, not only about the importance of UPR, but also in terms of overall progress on human rights, is still lacking in Malaysia. We can admit that. There's so many things that need to be done to make sure that our people are fully aware in terms of human rights progress and what we need for the human rights promotion and protection in Malaysia. So this is a real challenge. Perhaps by putting in very serious focus on the implementation of UPR recommendation involving different stakeholders and publicizing the outcome or the status of the implementation of those recommendations in addition to regular consultations by line agencies will help create kind of, at least to some degree, awareness among the public in Malaysia, the importance of all these human rights issues in Malaysia. Thank you.
If I may say that the question on freedom of religion as posed by the countries like Haiti, the United States, they can all be combined into one thread. And because you can spend lots of time going into the specificity of a particular case, dig out the details and things like that. It happens in any country for that matter, freedom of religion. But when you look at freedom of religion, it has nothing to do with a problematic religion or things like that. It's about freedom. And what I want to say that masqueraded in this sort of freedom of religion is actually not about religion. It's not about race. And when you look at the situation, you will find there are so many proof and instances where we live in a multicultural society and we are happy about it. But the problem is not that. The problem is about politicians politicizing religion and race. And the problem is about power. So when I look at this, then I begin to think along a line that should address the issues rather. Thank you.
I just want to add on to what Roger had said, and it's true. It's actually about the politicization of race and religion that is very problematic. I think if you go down to Malaysia, you won't find the peoples from the different races and practicing different religions having so much of an issue with each other. So I was a bit perturbed to read about in the addendum from the government of Malaysia, saying that they want one of the ways in which to deal with this is through a National Harmony Act, something which has been mooted before and then dropped. It should drop it again, because I would highly recommend to Malaysia that we should look at an Equality Act, because an Equality Act will look at different sorts of discrimination, how they intersect, and how to deal with it in a more holistic way. So the other thing about an Equality Act, I would say maybe look at England. England has a very effective one. And one of the ways in which they deal with it is there's law, but maybe not so much going into court. So under the Equality Act, they actually combined a few other acts that they had before that had discrimination issues on different statuses. And so now, their Human Rights Commission is known as the Equality and Human Rights Commission. So I would say to Malaysia, we should have an Equality Act, not a National Harmony Act. And we should actually strengthen SUHAKAM to deal with these issues so that people don't end up going to court all the time. Yeah? So, Equality Act, strengthen SUHAKAM.
Thank you. And I believe there were a few more hands. Yes.
Thanks so much to the panelists. That was really interesting. I'm Lisa from Civicus, and there were UPR recommendations to create an enabling environment for civil society that were accepted. So please could you indicate what steps have been taken or are being planned, in particular around freedom of association in Malaysia? And also, one of the recommendations made was to revise the Peaceful Assembly Act to bring it more in line with international standards. And we understand that the Parliament is putting forward amendments. And are there any indications that there's been consultation with CSOs on these amendments? And what changes are being made? Thanks very much.
Great. If we can take maybe one more. Yeah. Okay, if there are no more questions, then we can go ahead and proceed.
Thanks for those comments. Maybe I'll just take on the earlier issue of freedom of religion. I think that's a tough issue on the difficult list that needs to be handled. Most governments, their manner is don't handle it and hopefully it will go away or maintain. And I think this new government sadly cannot choose that option, because then it's not doing this new Malaysia that Ambassador spoke about will not be a new Malaysia. So it's difficult. I think some examples given, like unilateral conversion. We need to educate the public, because the concept of equality, I think, is now being exploited to try to speak about superiority. And I think this Malaysia can never and should never condone any such thinking, neither by political parties or what. No? Islam's special position in the Constitution is a special position, but it's not to give the notion of superiority, because then Malaysia was actually very strong in its advocacy on fighting superiority of South African apartheid regime. And I don't think we should ever forget that we are a nation that played important roles on minority protection all over the world, and you need to do that back home in Malaysia. So while it's difficult, I think the colleague who mentioned about rejection or not taking up, I think I also want to make a comment, Ambassador, that the word used here by the government is noted. So I would want to take a very progressive understanding of the word noted, and I think the issue is still alive, and because it's not rejected. Rejected means they're not going to take it. It is noted, and I think it's us who have to make it alive again. It's difficult. This new government took on many things that they did not sign up to, but that's how a nation and a government should be. And I think that also speaks then about the other new bills that you were saying of creating the open space. Open space is there, engagement has happened, but the laws need to be amended, and that's what I think the process of engagement is not so systematic. I think all ministries have opened up their gates. Ministry of Foreign Affairs actually is a regular engagement, but other ministries are ad hoc. And I think whether you ask a question on Freedom of Assembly Amendment, I don't think even our SUHAKAM Commission has been invited yet. And by law, we are supposed to be invited to give them advice on policy amendment. So I think the institutional engagement with civil society as a partner, institutional engagement with the Commission and the Bar Council as statutory bodies needs to be systematized in all ministries. Maybe they could follow the foreign ministries, 6-monthly, proposal as a way. For now, there is none. No cabinet decision on how each ministry must do. It's up to the ministry and the ministers. So you get lucky with ministers who really want to move it forward. If not, so I would propose that we push the agenda on the agreements by making it happen. And I think the 6-monthly reporting on the opening up of spaces. In terms of newspaper, radio, there's so much more faces not seen before now invited. I think Rizal here, I've seen him on television twice or 3 times. I never saw his face before. So civil society actors are now being invited to speak on air. That's good news. I think so. There is one place opening up, but I think my final point is, while you open up the public space, we need to go down to the villages, to the government, and spend time to discuss this notion of what equality means, what respect means. No religion is going to lose out. No Malaysian is going to lose out with more rights. I think that's the message that we need to take to all. Thank you.
Well, thank you so much to everyone in the room for joining us, and especially to our esteemed panelists. Oh, sorry. We have one question online. Very quickly.
So this question is on global compact on refugees. Given that the foreign minister made a strong statement of support at the adoption of global compact on refugees, pending the ratification of the 1951 Refugee Convention, are measures, and if so what, being taken to provide refugees and asylum seekers with legal status and work rights? So that's one question, and then the other question is, the government has accepted outright 4 recommendations on gender equality, yet it has only taken note on 4 recommendations for gender equal nationality laws. How does the government plan to accept gender equality without setting right gender equality in the nationality laws, which is also the root cause for huge numbers of Malaysians becoming stateless? So these 2 questions.
Maybe just briefly on the 2 points, global compact of refugees. Of course, Malaysia participated actively in the process, both in Geneva as well as in New York, during the final adoption of the compact on that. When it comes to the refugees and asylum seekers, I think many have noticed that there's been a change of attitude by the EU government, meaning that we are more concerned with the welfare and well-being of these people now. There's been a serious discussion about their well-being, including the access to health, access to education, and provision of humanitarian assistance. Despite Malaysia not being a party to the 1951 Convention and 601 Protocol, but the government began to take steps to give attention to these people of concern. That's what we used to know them as people of concern. Now we are openly calling them as refugees, recognized as refugees and asylum seekers. I think there's a step-by-step kind of improvement in this area undertaken by the new government. On the gender equality, I'm not so sure about the question.
Yeah. So this has to do with the ability to confer nationality to for wives who
married, women married to foreign men and delivering children outside Malaysia.
It's quite a specific question. I have to check again the facts. I don't want to give a wrong signal on this. But I think the overall gender equality situation in Malaysia, there is now a bill that's being drafted on gender equality and also empowerment of women, if I'm correct about that, or anti-harassment bill or something like that. I think it will be tabled in this current sitting of the Parliament. Thank you very much.
Okay, just a final note for, I think, the government of Malaysia to also note, while we are all focusing on the issue of citizenship, another key aspect of the law that affects women is on domicile. So in law, domicile means an intention to permanently reside in the country. Now, our Malaysian law is very patriarchal and archaic, so married women take on the domicile of the husband. So if you are married to a foreigner, it becomes very problematic when you want to institute certain proceedings in court. So that's another thing that we should look at, not just citizenship, but the issue of domicile.
All right, thank you so much. Obviously, Malaysia is at a crux right now in adopting some very large safeguards for its population and to promote human rights. And we really do hope that the recommendation outcomes that they will be responding with tomorrow are in adherence with international obligations of the country. And we hope that the progress that we've seen with the new government continues and does not backslide as well. Thank you.
Thank you.